So good morning and welcome to the Friday, June 10th, 2022 Public Clemency Board meeting. Before we begin, I wanted to provide a reminder about a few housekeeping rules for the meeting. First, please make sure that your microphones are muted when you are not speaking. If you have any questions, please hold them. We will have a period for questions. However, feel free to take advantage of the chat function and to send questions in, and we'll be happy to address them during the question and answer period of the meeting. I would first, before I take attendance, I want to just tell you that I regret to inform the board that two members, Andrew Foyce and Reverend Samuel Whitaker, have resigned from the board. Reverend Whitaker no longer meets DC residency requirements, and Mr. Foyce was appointed by President Biden and confirmed by the U.S. Senate to be chair of the Administrative Conference. We will miss the wealth of experience and the wisdom they brought to the Clemency Board, and we certainly wish them well in their new endeavors. So with that said, now I'd like to take attendance of board members present so we can make sure we have a quorum to proceed. I'll call the names of board members, so please let me know if you are here. Felisa Carter.
Here.
Emily Gunston.
Here.
Sonia Wael or Antonio Nunez. I think they're not able to join. Katia Semenova.
Here.
Ilana Suttenberg.
Here.
Great. So we have 5 members, and we need 5 members to reach a quorum. So we'll proceed with the meeting now. On the agenda for today, we have the review of the Clemency Board operating guidelines. However, before we begin reviewing the operating guidelines, I just wanted to again thank everyone for their service on the work that we've done with these guidelines. It's been pretty heavy lift, and I know our staff director has also had a great deal of involvement in formulating these. Also, there have been a number of comments from the board on both our outreach materials and on the content of these operating guidelines. So just want to say thank you to everyone for doing that. We appreciate their help in finalizing the board process, as well as that as the public. I'd like to now turn it over to our staff director to review the edits that have been received and the comments that have been received. We'll take questions on the operating guidelines after that run through. We ask that you hold your questions until the end. With that, Christina.
Thanks, Patrick. Good morning, everyone. Thank you so much for your time to review the guidelines, and thank you for your feedback and comments. Took an opportunity to respond to them as best as I could, but a lot is still left for the board's decision. So we probably will have another round of review before we can fully finalize these, just by the nature of the questions that are still outstanding. Hopefully we can resolve many of them on today's call. So I will share my screen with you. And just let me know if you're able to see the document well enough, or if it's you need to zoom in a little more. Is everyone able to see it? Should I zoom in a little more? Just want to be able to still see the comments. Okay.
That's better. Yeah.
Okay. Okay, great. Let me know, because I can't really see you on my screen. It's just all white as the document. Can only see who's speaking to me. All right, so we'll just start from the top. I don't see any comments on. I want to make sure I didn't pass any. Okay, great. So one of the first comments was from Ilana. You mentioned that at hearings that you don't anticipate that USAO will be voting on these or participating. I guess we just try to discuss with the board did you want that enumerated in the guidelines, or is that something that you just wanted to mention up?
Sure. I just wanted to clarify, if the expectation is that each member will do that, and we will not be doing that. I just kind of wanted that to be a little bit clear so that it didn't seem like we were failing to meet expectations. I think we're all on the same page about what will be happening, but I just didn't want to appear negligent or derelict.
Thank you, Ilana. Okay, so here.
Excuse me, I'm sorry. Just on that, I just wonder, is there ever going to be a time when the U.S. Attorney would be able to participate as a voting member, or is that something that you foresee? Like, are there some matters that you could opine on and others not?
Yeah, so basically kind of zooming out, our whole constraints are because obviously we're part of the Department of Justice, and the pardon attorney is basically the person who is delegated to speak on clemency matters as the Department of Justice component, and we are not that delegee. And so that is why we are limited, and we've worked with the pardon attorney just to clarify what we can do and can't do. But because the pardon attorney is the DOJ designee to handle clemency, that is why we aren't going to be participating in individual cases. So we wanted to participate to kind of be part of this process and kind of help think through some of the structure and kind of provide whatever feedback we can, but I don't expect that we will be participating in individual cases.
Thanks for the clarification.
Okay, thank you, Lana. The next question was with respect to, I think, Katya, you brought this up, that designee members of the board should be able to speak with other designee staff or people within their offices concerning a particular case or matter before the clemency board. And I went ahead and added in a bit of language that allows for that. I just wanted to open it up for the board. It would say that board members who attend closed sessions, meetings, and hearings shall not disclose what occurred with anyone who was not in attendance unless disclosure is with other board members or agencies of designee board members and in compliance with the Clemency Board's regulations, section 705.7, which essentially deals that you do it within all your professional ethical responsibilities. So within the standards of, so whether you're an attorney, you have particular ethical conflict of interest responsibilities. If you're a health professional, you have those. So that's what that section of the regulations deal with. Just wanted to open it up to see if it satisfies your concerns, Katya. I believe Ilana also had similar concerns.
Yeah, that addresses mine.
Okay.
Can you just scroll down so I can see the whole language there? Sorry.
Further on the.
Oh, I'm sorry. I'm sorry. You redlined it. I was looking at Katya's comment. And just to clarify, I think that we will be not probably participating in individualized cases, but to the extent we did, I think this would be expansive enough to include our conversations with the whole Department of Justice. But I just want to clarify that that's everybody's understanding, because we would, with the whole Department of Justice, we might discuss things.
You think the whole Department of Justice is the designee agency?
You're right. It is not just the U.S. Attorney's Office. I mean, part of why we're not participating is because we do have communications with the pardon attorney. That's, part of their official policy, is that they communicate with the prosecuting agency. And so I just would want to ensure that we could, that we wouldn't be limited in our communications with particularly the pardon attorney. I don't anticipate that many other executive agencies. So I do just want to kind of clarify that. You're right, Katya, that I think that under the current language, it would need to be more expansive.
I mean, I wonder if Is there a world in which the United States Attorney's Office doesn't participate, but then communicates negative comments to the pardon attorney, which has the control over the ultimate grant? And as such, should the U.S. Attorney's Office then be limited in what it communicates to things that are consistent with the official position of the Clemency Board?
So I can't limit us in general at all in terms of our communications with the pardon attorney. Obviously, those can range depending on the facts and circumstances of each case. And I certainly want to not limit any communications that we might have that are otherwise appropriate. I mean, part of, the reason that we're being limited here is because we are also involved with the pardon attorney. So, to the extent we need to clarify it, we can do that. We will be having these conversations with the pardon attorney separately regardless. And so I do just kind of want to clarify that and not limit otherwise appropriate communications.
I guess, Ilana, just for clarification, what are the concerns with being a voting member and a participating member to provide just a letter of recommendation to an applicant? It's not going against the purpose of the pardon attorney. I wonder what the concerns are there if it's just a letter of recommendation and why the USAO can't at all participate holistically.
Sure. So I have, sought internal ethical guidance within DOJ, and that is their position that this is the most appropriate set of circumstances to kind of ensure that we're complying with all of the pardon attorney regulations. So this was kind of a way that we could provide helpful feedback to the board and hopefully participate and kind of help facilitate the startup structure, but then also comply with the regulations that really limit our involvement in the clemency process at all and really exclusively designate it to the pardon attorney within the Department of Justice.
Okay. Well, I leave it to the board if they're okay with this expansive language to decide to move forward with it, but I added it in to allow various designees. Certainly you're covered within your specific designated organization. I don't know if it necessarily applies to the full DOJ. Honestly, Lon, I don't have an answer to that right now, but I think that's something we're considering to consider when adding this language. Any other comments before I move on? Okay. So Professor Moyd presented a
So
question.
I'm sorry, just to go back on that. So are we going to clarify that it would allow us to disclose further beyond just the U.S. Attorney's Office, or?
I don't think we're going to be voting on them just yet. I think these edits will go back. So if anyone has additional changes they would like me to make to the current draft, the red lines, then let me know. I'm happy to do them as we go. But
okay, great.
We would just like to leave them and then send them back for review unless they don't.
Okay.
Unless you have any other changes. Yeah. Okay. So this comment came in from Professor Moyd. I think Professor Moyd, your question was how does this fit with the prior discussion that EOM would hire a full-time administrative person? So the breakdown of the staff responsibilities, the staff director is the full-time employee. This narrative at the bottom just indicates that other employees within the Office of General Counsel may provide support to the Clemency Board as well. So it would be additional help to the staff director.
Thank you for that. I didn't know that the staff director was that person. Thank you.
You're welcome. Okay. Another question from Professor Moyd was that public comment should be mandatory at all regular meetings for the Clemency Board. Certainly the Open Meetings Act does not require that public comment is mandatory. Public attendance and access is mandatory. I think you should allow for the board to have a little bit more flexibility because there might be instances where public comment is not necessary for different board meetings. And currently by law, it's up to the discretion of the board. So just wanted to address that concern for you, Professor Moy, and see whether or not you had any additional concerns for the board to address.
So when I read that, my concern was the language that says public comment if there is time, you know, and the chair wishes to have the public comment. I just think that if the public takes the time to attend a meeting, then time should be made for them to at least speak if they choose to, or an avenue designed so that folks can submit comments even after the meeting. I just think that if the public takes the time to attend the meeting, then it would be great to at least hear from them.
Thank you, Professor Lloyd. No, I mean, certainly we always give moments for public comment, such as now we're very integrated in our comment period. It's just not required, and I don't think it would be in the board's best interest to require it at all times, according to the Open Meetings Act. But as you can see, we're very open, and that's what the board does, but it's up to the discretion of the chair. I didn't know if other board members wanted to.
I just want to clarify, you said that is by the Open Meetings Act, that is?
It's not mandatory, but it's up to the discretion of the board based on what you're trying to accomplish at the meeting. For instance, if you have a meeting where the public attends just for a voting, when the board's just voting, if you add a requirement for public comment, I mean, when council has particular hearings, they're not required to have public comment on every meeting. So it's up to the discretion of the board and what you're trying to accomplish.
Okay, thank you for that.
So I just wonder if the language then should be changed to just sound a little bit more welcoming and inviting, or even neutral, to say public comment will be allowed at the discretion of the chair, as opposed to if there is time, which kind of makes it sound like you're shutting people out. Just my thought.
Sure. If the board doesn't have a concern with that, I'm happy to add.
Yeah, I think that's fine. Ultimately, the point here is the chair can decide.
Just making it based on the discretion further limit public comment. I think if the concern is that public comment should be supported, then just making it at the discretion means that even if there is time, the board chair can decide not to allow the public comment. So it could be if there is time consistent with the discretion of the board chair, like if one person is using all of the time, that would allow the board chair to limit it. So that more people can share.
Could we just quote what it says in the Open Meetings Act about this? Just take that exact language.
It actually doesn't speak to public comment at all. It just says there's public attendance and access. So it doesn't provide any language to that. It's the chair who determines how meetings are conducted. So I think if you leave it as broad as possible, so if there's more, speaking to what Katya stated, if you want to assign like a minute to each public attendee because we only have 10 minutes left, I think leaving it up to the discretion of the board keeps it just as broad without having to provide specificity that the board chair can divide it up based on how much time is left over. I think just saying it's up to the discretion of the chair would allow that flexibility. I think you're on mute, Patrick.
I was just checking it to see if that answered Katya's concern.
To just allow it to the board chair. Sorry, the discretion, yeah.
Right.
I mean, I think either way it's discretionary. So it's yeah. I just wonder, my only comment was that it seemed to make it worse from what Professor Moyd was advocating for, if it's just at the discretion, whereas if there is time, seems to provide, seems to create the requirement for it if there is the space for it.
So but I think saying if there is time goes back to our main issue of it not seeming as welcoming. But if there is time, if there's time for public comment.
Or you could say something like, public comment will be permitted at the discretion of the chair based on time allotments or time constraints.
I did not catch that. Sorry, my brain went quiet as soon as you were done, Professor Moore. Public comment will be allowed.
I just said at the discretion of the chair based on time constraints.
Thank you. Does that address your concerns, Katya?
Yes.
I will move on unless there are other comments on that. Okay, so here, okay, so Katya, your question here was with respect to, so this deals with open meetings and confidential proceedings. So that board proceedings are open to the public and subject to the Open Meetings Act, and that the board shall close a meeting or a portion of the meeting to the public. And so it's now speaking to the closure of those meetings to consider applications for clemency and discuss matters that would allow for the identity of any person who's subject of the discussion. So it closes a meeting for those. And your question is, has everyone who has applied consented to open meetings? So that no, all considerations for applications for clemency are done in closed meeting. And then would this provision always allow victim impact statements to be confidential, and would the applicant get to see the victim's impact statement? So since considerations happen in closed session, we're going to get to the hearing proceedings a little bit later, but I think this might warrant a good discussion for the board, whether or not, I think the goal is to provide more of a victim-centric approach, that not all victims will want to provide a statement. They probably would not want to even have an opportunity to re-traumatize themselves that way. And then you might have victims who do want to participate. So I think allowing for that flexibility is good, but the board should really consider whether or not we would want applicants to have access to that victim impact statement. I just wanted to open the floor for board members for consideration of that.
One other consideration is, oh, sorry, to the extent that the pardon attorney is later considering these and, wants to review the statements either of the victim or of the applicant, I think that we need to, I think it would be probably efficient to be able to provide them to the pardon attorney, at least in summarized form, perhaps, so that they may make consideration of those in whatever way is appropriate.
And certainly we could let victims know that ahead of time if that is necessary. And that might weigh on whether or not they want to provide a statement or not. So it doesn't warrant making edits here, but that certainly will be a conversation we can save for the hearing procedures, which are a little bit further on in the board operating guidelines. But I just wanted to address it here since Katya brought that comment up. Any other comments, questions? I know we'll get to it later. Okay.
Yeah, we'll move on.
Ilana, your question here is, does this apply to applicants, victims, or others who appear at the hearing? How will we prevent them from disclosing information? And what is the rationale for doing this? So persons other than board members who attend any board meeting that is closed to the public shall not disclose what occurred at the meeting to anyone except insofar as disclosure is necessary for that person to comply with the request of information. It's very hard to control public members that may attend, so maybe a witness. I think just having this here is to just stress the importance of confidentiality and encourage that in closed meetings. The rationale is to do as much as possible to protect the confidentiality of the applicant and what was discussed at these closed meetings, that it is not public, open to the public.
I recognize the rationale for requiring the board members to do that, but in terms of kind of people appearing, it just, to me, in my head, I kind of analogize to grand jury, where there's very strict rules on, the government, court reporters, the grand jurors not disclosing, but somebody who goes into the grand jury is not, like who testifies is not precluded from talking about it to someone else. And, I think that it might be appropriate. Like, what if they want to tell their spouse about what happened, or kind of have another person that they want to talk about? It just, I totally understand it for board members, but it just seemed like there was less a rationale to do it for other people who might appear.
Part of the reason why I included this information is that was required by the Clemency Act, but I will leave that to the board to determine how it would like to address it. It's just required by the act that establishes it, but we can certainly, create a little bit of a modification that allows us to be in compliance with that requirement.
And that gets handled through Appendix B, or?
It's, no, it's how it would be handled would be part of the hearing procedures.
Okay.
But yeah, no, the way that the source of it comes from the Clemency Board Act, which is under 24/481.
And sorry, you're right. I did just reread the statute, and that is indeed exactly what it says.
Yeah. So I agree. In many ways, I do agree with you. It's very hard to control and require that of other members of the public, but it's just in here because that's what's statutorily required. Unless we change the statute, it's what's requested of us. Any other comments?
There's like a list of things that we would ask the council to clean up at some point in the statute. This would be one of them, because I do think for the reasons that Alana said, and it just doesn't make sense to then, I don't understand how this would be enforced,
Right.
policed against people who want to speak with individuals about what happens at the hearings, even if it's, if it's a witness who appears on behalf of an applicant who then wants to say, I supported applicant at this hearing. I don't see why they should be barred from sharing that.
Right, no, certainly in total agreement here, but I think if the board would like to do that, that's totally within your discretion to make that decision to send a list of issues if that's what the board votes to do.
Yeah, I agree with, this is Felicia. I agree with Katya. I don't see how this is, how this could be enforced. I don't know who would, yeah, we can't do anything about it, but if we found, as the board, if we found out that someone did say something outside of the hearing, Who do we refer that person to? And do we want to be in, do we want that burden or responsibility? So, yeah, I don't see how it can be honest at all.
Right. Well, I'm happy to draft up a list if that's what the board would like to do.
Yeah, I think that's a good idea to at least keep a running list for now.
Right. Thank you all. This section right here, I just added the same information as above that board members should be able to discuss with their designee organizations what's happening in closed meetings. And this applies only to board members who are designees. So that would be OAG, the PDS, USAO, and council. The rest of the board members would not be able to speak, to take that back to their, because they're not designee. They're not designees, they're board, specific board members, appointees. Okay. So this was just a quick edit from Professor Moyd that the official date of completion occurs when all necessary background information and documentation is received by the board. It was just to change around a bit of the language, instead of saying obtained from law enforcement agencies, but just in keeping it more general. Any concerns with the board adding that information? Okay. So here under section 3, Professor Moyd recommended a case will only be deemed closed after the staff has written communications to the most recently verifiable mailing address and via certified letter or the institution most recent verified BOP or DOC address. So I just want to encourage the board here to not limit where we can send. Our regulations should be just as broad. So by putting in that we'd have to find a verifiable mailing address or a BOP address, it limits what the applicant may want. So it should be based on what is written in the applicant's address. They may want to use a family member's address to receive that information rather than a BOP facility address, partly because, you know, we're also dealing with mail being open at BOP facilities. So my recommendation would be to keep it as general as possible.
Any comments on the recommendation? I mean, as a matter of operation, we can do it that way, where we make a determination that, you know, this is the best way to make sure that this person has been notified.
Okay. No comments, I'll move forward. So Professor Moyd, thank you for this clarification. Going back to the comment above, just dealing with confidentiality and access to background information. Granted, we do get an ROI from an applicant to share this information, the letter of recommendation and supporting documents with the board and the DOJ pardon and the President of the United States when ultimately a letter of recommendation is made. But part of getting those background documents is not dependent on us. It's based on how those agencies make those recommendations. And transcript seems to be our only obstacle right now. It's a cost. Right now, the way that the process is established is accessing transcripts are on an as-need basis, and they would be accessible on the Superior Court's website, and an applicant would have to request those themselves because they come at a cost, and the court the way that transcripts work, that they're not always fully done for every single case or every single sentencing, but if they are, there would be a copying cost. If they're not, then there would be a full transcription cost that would have to be submitted to the court reporter's office. So it's a cost not imposed by us, but a cost imposed by the courts.
I just wonder if in cases where the person is deemed indigent, how can we, the Clemency Board or some other supporting agency, help that person get transcripts if they need them? It just seems like there should be a way for someone to be able to get transcripts and not bear the cost if they're unable to. I understand that sometimes folks will be able to, but if they're unable to, it just seems like we should think about a way to absorb that.
Well, certainly, Professor Lloyd, it's just for right now that we'd have to think of a way to be able to help individuals in those circumstances. I think that that's something that the board can certainly look into. And I don't know if we have other ways of doing this, but for right now, I'm just trying to think more broadly of how we can, in this application process, not impose such a cost on an applicant based on the way that our application is written. If you go on our website, the transcript is written to be received on an as-need basis. So unless it's specifically needed, we wouldn't require that to be a cost for every applicant unless we really needed to see what occurred at a sentencing or what occurred at a trial.
Yeah, there must be some community group too that could be brought to bear, some help with this as well. I agree. I don't want there to be an obstacle based on someone's financial ability to pay for a document. I just don't know that the board is the one who can make that remedy available. And maybe, I mean, certainly there could be an opportunity for some grant receiving organization to be granted money to take care of things like that.
So the other thing I think of is in many cases, the CJA attorney or the attorney assigned to the case may have requested the transcript and may already have a copy. I know with DC Superior Court, typically, you can get a copy of the transcript transcribed pretty quickly if it's already been requested. So I don't know, Katya, if there's a way to know whether a transcript has already been requested in the case. I just don't remember how that works.
It's just calling the court reporter's office, and then it makes it much cheaper. It does make it faster and cheaper. The copy rate is, I think, like $1 a page versus $4 or $3 a page otherwise. It might even be less than $1. But it's significantly cheaper if it's a copy, and they could call court reporting. But again, if it's somebody who's incarcerated, it's going to be really hard to call court reporting and ask. But we could call, the Clemency Board could call and see if a transcript has already been done. The person should be able to access their own file through their lawyer if it was transcribed and requested through their lawyer.
Okay. No, certainly seems feasible for us to check and see if there's one already done for their case. But I'm assuming if there one isn't done, then the standard transcription fees apply. Okay. I don't know if there are any additional comments with respect to transcription fees. I will move forward. Okay, so a copy of this deals with mail being opened. This Professor Moyd highlighted a concern here that a copy of the letter recommendation and supporting documentation will also be sent to the applicant for record keeping purposes. And just bringing it up to the board if there are any concerns here. Professor Moyd indicates that yes, all mail will be opened, but in the presence of the individual.
Yes, that was merely to just state practically what happens is if it's stamped legal mail, then it's open in the presence of the individual. That might, help to maintain some confidentiality.
And we can certainly make sure that when it's sent that it is stamped legal mail if the board would like to do that.
Yeah, I think that's good.
Okay. Would the board want to add that here, that it be stamped legal mail?
Just to clarify, others have far more experience with this than I do in terms of sending mail to incarcerated people, but would this be legal mail? Like, is that an appropriate designation? Wouldn't that just be, protected attorney-client communications?
What do you mean? What's the difference? I mean, there is a difference, but I think it all falls under legal mail.
I actually don't know, so I really defer to other people who have done this much more than I have. But if it's a non, if somebody is sending, like, do you need to have an attorney-client relationship for it to be legal mail? I guess that's
For
my
it to be
question.
legal mail.
That's my question.
Yeah. Mm. That is something that we could clarify with BOP.
I am not entirely sure, so that's why I can't speak to this, but we can certainly find out more information.
This is
I think
Felicia.
that-
Does it?
Go ahead, Felicia. Sorry.
Does anyone know if how I guess any mail is treated from maybe a parole board or like organizations like that? Are they given any special consideration for mail sent to inmates? And if it is, can we fall under that same consideration?
So, you raise a great point, Felisa. For our purposes, the BOP has considered us to be sort of a legal entity. Just to give a little bit of background, we had reached a BOP to kind of allow us to have access to their video conferencing services to conduct hearings with individuals in BOP facilities. And the way that they did that was put us within the legal context, that it is a legal proceeding and would help in that way. So that's how we were able to get access. So it might be very easy to have our mail qualify as legal mail just because of the sensitivity of the information in it. But I'm happy to look into the parole board and other boards who have of similar contact and information that they exchange to see how they deal with their mail.
I would also suggest that you check with CIC, the Corrections Information Council, because I know that they do mailings to folks in BOP, and I believe theirs is considered legal mail. I'm not certain, but I believe it is.
And Christina, this is
And those
Jeanette.
would be folks that they have not necessarily established a, legal relationship, attorney-client relationship with, but they do those mailings.
Okay, we'll look into them. Tanette, I believe you had something to say.
Yeah, I did a quick search and I did find some information regarding the regs for that. So I'm happy to send the link that I found to the board. But it does look like there are different specifications, but it seems like it's already set out. So I'm also happy to look into that further.
Thanks, Tanette. Okay, great. All right, we'll move ahead. So this was really the actual innocence issue, just to get more clarification. Professor Moy just wanted to highlight that, it is required by the 2018 enactment that the board must consider cases of actual innocence. And I think we've brought this, the concern here is that the board is not in a place to make determinations of actual innocence. So how we review those cases of actual innocence, I think needs further clarification. Does the board step in and provide a letter of recommendation after an actual innocence determination has been made by a court, a trier of fact? I think those procedures need to be fleshed out, but based on the Clemency Act, yes, cases of actual innocence do get considered. It's just about fleshing out at what point.
So Christina, is that something your office is looking into or doing further research on?
So ultimately we can, it's just we're very limited. It makes, to be frank, the board can't really step in on cases of actual innocence. We just don't have the capacity to determine that. We're not a legal body. We don't have a jury, we don't have a judge. So we wouldn't step in on those, but more so we would step in where, let's say there was a new evidence and then the court determined that this individual actually is innocent, then the way that I would see the process working is that they could apply to the board and say, a court has determined that I am actually innocent. Here is the final ruling. And I'm asking for a letter of recommendation from the Clemency Board to help me petition the President of the United States for clemency.
So if a court makes a finding of actual innocence, the odds that it will come to us feel unlikely. They'll probably be released and it will be sealed. I mean, it's, I guess, in a theoretically academic world, not impossible, but it just feels pretty unlikely that this will actually be an issue where somebody has been found to be actually innocent by a court.
And that's why I just.
But as it stands right now, we just can't deny the cases because how, I guess, the applicant who wants to apply under this consideration because of how these, I guess, how the statute was written. So we're just in limbo, but we can't deny them.
So my understanding of the statute, which I know I've said before, is, I think that somebody who claims they're not actually innocent would not be precluded from applying for relief under the Clemency Board. Having said that, it is not, the board just doesn't have the capacity to address whether the claim of actual innocence is valid or not. And just, I mean, if there's like DNA evidence, like there's just a lot in there, and USAO will not be involved, and we were probably the one who prosecuted them in most situations in the first place. So I just think that it's just deciding the issue of actual innocence is just beyond the capacity of the board, but it just doesn't preclude somebody who's asserting they're actually innocent from submitting an application. And that's how I read the board, how I read the statute, I'm sorry.
This is Emily. I think the statute is open to interpretation. I agree though with Ilana's perspective that with regard to, it's important to include that here to say we can't not consider it because the person is claiming actual innocence. If we as a board though think that there is a place for the board to be considering actual innocence, I think we would need a whole other process to do it. Right? We couldn't do it based on, we would not have sufficient information to consider a claim of actual innocence based on the information we've requested in these documents, and a hearing like the one we've described in these documents wouldn't be sufficient to do so. So, you know, I think that we need to make a determination as a board how we're going to interpret that. But in any event, if we are going to interpret it to say we're considering claims of actual innocence, I think we need an entirely different process to consider those.
I'm also putting in the chat the link to the Justice Manual, which describes obviously the pardon attorney and how they, you know, their regulations that bind them. There's a role of the prosecuting component, which would be USAO in this situation, and there's a discussion of actual innocence within that part, that if there is such a claim, then that's basically something that the prosecuting component would address to the pardon attorney. I recognize that that is different from what this board is doing, so just noting it.
Any other comments?
So I guess as a resolution, we don't have a resolution. Is there something that a list goes on the list of things that we need to figure out, revisit as a board?
Well,
Things like how much process we have, how much process do we give to a person who claims actual innocence? We want to go down their road, or, I mean, I don't know if we have a choice right now, considering how the statute is written, but yeah.
All right, so I'm the non-lawyer here, and when I read this sentence that's highlighted, in considering applications for letters of recommendation for actual innocence, the board shall consider cases of actual innocence as determined judicially. So does that mean there's a judicial determination that the person is innocent, and then we will write a letter?
A letter of support.
So
I don't think that's statutory language though, Patrick.
No, it isn't.
I think the statutory language is the first sentence. Consider both cases of actual innocence and cases of those who are remorseful and can demonstrate they've been rehabilitated.
okay, but our determination, you know, as it's written here, is that we'll only look at these cases once there's been a judicial determination of innocence. Is that correct?
That's what it says now, at least because it's open to interpretation. The statute doesn't provide a lot of guidance, nor does, you know, looking back at the intent of what its creation, how would that work, doesn't provide a lot of guidance. So for us as a board in our capacity, I think we're statutorily required to consider cases of actual innocence, and I think our process should be to consider cases that do have judicial determinations. And while Ilana highlighted a great point, was that, you know, those cases might be sealed and the person might not even need to come to us in the first place, then ultimately, how is the board going to play a role in cases of actual innocence if that's not a necessity for people who have judicial determinations of actual innocence?
I agree that the statute is confusing, and we've talked as a board many times about the potential ambiguity here. I'd have to say though that I think the interpretation of we consider applications of actual innocence if a court has already determined that they're actually innocent is not a reasonable interpretation, because if somebody's been determined actually innocent, they don't need clemency. We would never see those cases.
It's a fair point. So ultimately, what is our process?
I just wonder, I think we've been around and round on this as a board. I think that there's, right, the two interpretations that have been put forth are, one, that the language means that we're not precluded from considering an application, even if the person is claiming actual innocence, i.e. they don't have to demonstrate remorse, right, if they're claiming actual innocence. The second interpretation that's been put forth is that we're to engage in some sort of determination to decide whether or not we think they should be granted clemency because they are innocent. And I just don't know how to resolve on this board how it is that that statute should be interpreted. And I wonder if we should consider a process to reach resolution there, whether or not that is going back to the council, voting amongst ourselves, what we think, how we think we should be interpreted. I think we have to reach resolution here because it's come up over and over again and we've deferred it over and over again. And at a certain point, we need to decide how we're going to interpret the statute.
This is Felisa. Did we ever get any, I guess, feedback from the council about specificity on the language, legislative history of when they drafted the statute, what they meant by actual innocence, or did we get any feedback from the council about that? I thought we were supposed to get something. Someone was supposed to look into that from the council member's office. Did that ever happen?
Yes, so we met in our in the application committee, and that's where we discussed this issue, but I think it seemed unresolved from our discussions. And I think that's the point, is that because of that, how does the board want to proceed in resolving this? We could go back to the council, we could, try to determine a separate process ourselves, but ultimately it would be the issue still stood with what Emily highlighted, was that, if there's no judicial determination, if someone comes in, let's say myself, and I'm stating that I'm innocent, then I also have nothing. How do I determine my innocence? By putting forward evidence that I'm innocent. But we don't have the capacity to look at evidence and make a determination of actual innocence. And if that is the case, the statute also asks that they must demonstrate that they have been rehabilitated in remorse. But if you're innocent, you have nothing to be rehabilitated from. So there was a lot of legal issues there, legal sticky issues. Because ultimately, if you're saying you're innocent, but then you say I'm rehabilitated, is that also sort of an admission in some way as well of fault? So there's a lot of sticky issues statutorily that need to be cleaned up.
So for sure, I would like this included in the communication that the board will decide to send to council. I mean, it's set, it's pretty plain language that the act says that we'll do this, but I think the fallout from that is pretty dramatic, and we have to really be thoughtful and make some recommendations about what would be better. We can't be trier of facts, and I don't think we're authorized to be that.
I am happy to add it to the list.
Thank you. And maybe we could have a group who's really going to focus very directly on what other recommendations we might have for the council in raising this issue with them.
Okay. Katia submitted a comment here to add in information that DOJ pardon initiatives, so initiatives started by the president, also be added in here, that the board may authorize the staff director to prioritize applications under any criteria identified of the board, including clemency related initiatives of the president of the United States. Added in
Sorry, go ahead.
Go ahead. No, no worries.
Sorry. No, you go ahead.
So I just added in that information just to be consistent with the regulations, because it is in the regulations as well.
Yeah. I like that. I just was thinking that for the innocence question that Emily raised, that we should also be just asking the council to look at what it is that DOJ Pardon Office does with this, because ultimately it is going to be, they are the ones who are going to decide the clemency, whether clemency is granted. So I don't remember right now what their innocence process is, but we would want to match or put our applicants in the best possible light to actually be granted clemency.
I think that's what's in the link, and I can put the language in it too, but I think that they ask the US attorney, which I recognize is maybe not what this board is envisioning, but that's what I just cut and paste it from their website.
Thank you. I'll make sure to include that information in the letter. Anything else we may add as we go. So if the board has no concerns with this, I can move forward to the next issue. Okay, so here, Ilana, your comment was with respect to sending a finalized letter describing why we made like the letter of recommendation and supporting documents to the President of the United States and the DOJ pardon, and if certain supporting documents cannot be further transmitted consistent with the obligations to protect confidentiality, the board would make arrangements for in-camera viewing of such documents. As of right now, we don't have that concern that would arise with all the documents that we would be receiving. That was just a proactive term to allow that all for instance, if we send up the application and letter of recommendation, if there's a particular document that's highly sensitive by that particular agency that warrants not sharing, that we would still, rather than send it over, we would allow an in-camera review. It's just an option to provide, whether it be DOJ pardon that wants to see the full thing, or the president, let's say the supporting documents were not sufficient enough, they want to know more, we would provide in-camera review of that information.
That's fine. I'm just trying to understand it better.
No one has any concerns, I'll move forward. So here went ahead and I think both Katya, Ilana, and Professor Moyd submitted comments of there being some sort of structured procedure for hearings. So went ahead and put in some structure that we can certainly modify and change. I'm sure we'd all have lots to contribute to this, partly because this might be the meaty part of the work that we do as a board. But an overview of the hearing, that the purpose of the hearing is to gather additional information on an applicant beyond background documents received by the board, hear from victims and witnesses. There should be witnesses. Victims or witnesses in order to assist the board to reach a decision on whether or not to issue a letter of recommendation. And that hearings can be held during regular sessions meetings, but not be open to the public. So if the board meets in regular meetings, it would be eventually closed and then the hearing may commence. So it's part of like the Open Meetings Act to be able to start an open meeting and close it. The board may invite witnesses when evaluating the application of a letter of recommendation in accordance with the Clemency Act. Should a hearing be held, applicants will be allowed access to their own attorney or non-representatives in accordance with the Clemency Board Act, and that the board would not be providing counsel to the applicant, nor will the board or the district pay for counsel for applicants. And the order of business for a hearing should be a call of order, announcements of quorum, and then consideration of applications, and then adjournment. And the consideration of applications would be that we can certainly clarify that and put like applicant statement, witness statement, but We would provide notice within 2 months of when the application has been deemed complete of a hearing, if necessary, if the board determines a hearing is necessary. Each notice of the hearing shall contain the date, time, location of hearing, and the process for an applicant to inform the board of a need to reschedule the hearing. With the assistance of the staff director, notice of a hearing shall be given 90 days prior to the hearing if feasible, and will be sent to the applicant and the applicant's attorney or non-attorney representative, if any. Any concerns with this as of yet? We haven't gotten to the procedures just yet. This is just an overview.
So this is probably somewhere, but so let's just say an application comes in, like the mayor's office does a first review, like do other board members just can you just like provide a quick summary of like who decides whether it moves forward for full board consideration, who decides whether it like moves forward to a hearing, and that's probably somewhere in here, but I'm sorry.
Sure. No worries. There's a step-by-step process outlined here. We'll certainly get to it, but did I pass it? I think I did pass it. Yeah. Here. So it explains the whole process, the review process. So receipt of application, staff director will review the application for eligibility and completeness. That's Appendix A. And then the staff director, that goes into that whole 6-month period of if an applicant is incomplete, we send a notice twice to an applicant to make sure we get the application. But once it's deemed complete, it will move forward to the board, collection of background information of the application if found eligible. So we'd reach out to the various agencies to get their background information, and the evaluation. Once an application is deemed complete, the staff director will collect everything and send it to the board for review. And then within a week of deeming the application complete, the staff director will instruct the executive assistant to schedule a time for the board to meet in closed session to consider the application. So that's the process. And the evaluation application process, if a hearing is requested, that's all included in step 5. So that's where we were at, reviewing the hearing procedures. And then once the board reaches a decision, letters of recommendations are sent out. So is that helpful, Ilana?
Thanks, and sorry for the redundancy. I'm sure I read that a few weeks ago when I looked at it. So
sure, no worries. So going to where were we? Hearings. I believe it's further up. Oh, no. Okay. So with respect to hearing procedures, again, this is just something based on the comments we received. So the way a hearing will be conducted prior to the scheduling of a hearing, the board shall designate one board member to serve as a presiding officer for the hearing. The presiding officer shall be responsible for assuring that hearings run according to procedure. And at the conclusion of the hearing, the presiding officer shall be responsible for providing a summary of the hearing to the rest of the board. That serves to, in case there are board members that are not present at the hearing, they would have a summary to at least advise them of what occurred. Staff director by letter of notice will inform the applicant of the scheduled hearing and notice requirements were above, and determine whether the applicant will be presenting character witnesses, because there might be more than one. The staff director will identify and notify the victims or the victim or the victims or the victims representatives of the scheduled hearing and confirm the victim's desire to appear and testify or exercise their ability to present a written statement at the hearing. The staff director will make 3 attempts to contact the victims or the victims' representatives. Hearings will not be delayed because the staff director is unable to reach the victims or the victim's representative. A victim's attendance is voluntary and they may choose to opt out of the hearing and any related communications. Victim participation is not mandatory for hearings to proceed, for the hearing to proceed. On the scheduled date of the hearing, for a hearing to proceed, there needs to be a quorum of the board. Presiding officer shall assure the applicant, the victims, and the witnesses are sworn in and given their allotted time to provide testimony or a statement. The applicant may be represented by an attorney or any designated representative. The board will not provide nor pay for counsel for applicants. The applicant may present supporting witnesses and documentary evidence on their behalf. The applicant will have 10 minutes to present a personal statement on why the board should grant the applicant a letter of recommendation. Whether to allot more time to the applicant is within the discretion of the presiding officer. The board members will be allotted time for questioning according to the discretion of the presiding officer. The applicant may choose to reserve time to address the board following the conclusion of all other witnesses. The applicant's character witnesses will have 10 minutes total to present a statement in support of the applicant. Whether to allot more time to witnesses is within the discretion of the presiding officer. The board members will be allotted time for questioning according to the discretion of the presiding officer. Victims or victim statements will have, it was between 10 and 5 minutes to testify or present a written statement to the board. Whether to allot time to the victims to allot more time is within the discretion of the presiding officer, and that board members would be allotted time for questioning according to the discretion of the presiding officer. The order of testimony for the hearing will be applicant, character witnesses, then victims or victims representatives. So following the hearing, the board will meet to consider all information obtained from the hearing through the ROI process and the application to reach a decision. Prior to this meeting, the presiding officer will send a summary of the hearing to the full board, so all board members are informed of what occurred at the hearing. Once the board has reached a decision, the chair will instruct the staff director to inform the applicant of the decision. If the board decides to issue a letter of recommendation, the staff director will provide an initial draft of the letter of recommendation for the board's review and approval. The board shall provide an edited and final draft of the letter of recommendation to the staff director to prepare for submission on behalf of the applicant. If the board decides not to issue a letter of recommendation, the staff director will provide an initial letter of denial. The board shall provide an edited final letter of the denial of the staff to the staff director to prepare for submission to the applicant. So that was about.
Sorry. Can we add discretion for allowing more time for everything in addition to the victim impact statements, so that the director or the presiding individual in that top part? I just noticed it now.
Where is that? Sorry.
So sort of mirroring the language, maybe like it shouldn't even be just pulled within the victim section, but just generally a separate number point that says, more time for everybody, right? So there's the, oh, sorry, it is there. It is there for every individual one. I'm sorry, I missed that in the character witnesses. Okay, so it's just in each section, it says more time.
Exactly, in each section.
Okay. Sorry, I missed that.
Correct. It provides more time both for the applicant, the witness, the character witnesses.
Everybody. Okay, sorry, I didn't see that. I like that.
Ultimately, I think just here with advise, I think 10 minutes total might, for the victim, sometimes 10 minutes may be a lot. 5 minutes I think 5 minutes may seem sufficient to do that. So that would be my recommendation, is to make the victim impact statement or the victim's representative statement 5 minutes, because it might be, I think certainly we want to consider not re-traumatizing the victim in any way, but also leaving it to the discretion of how much they want to be involved, and if they need more time, the board let them have more time.
Can I ask a question? This might not be the right place to talk about it, and I'm sorry if we've already gone over this and I just don't remember what we decided or the process we came up with, but how are we going to get the applicant to the hearing, either by video or in person? Have we discussed a process to coordinate with BOP on that?
Yes, so we got access to their video conferencing. And they've given us permission to use it. So on that, we're okay with that with respect to BOP.
Okay, thank you. Sorry.
Sure, no worries. I think that you raise a great point, Emily, though, with respect to our process for individuals. You know, do we want these hearings to be done in person? Do we want them to be done virtually? For those individuals who are not in BOP custody.
I'm sorry, for those individuals that what?
Who are not in BOP custody.
Yeah, I mean, if the pandemic has taught us anything, it's, to try to make this available to people in the, a reasonable fashion that's secure and all that sort of thing, but that is also generally available. And, transportation to the Wilson building could be very difficult. So I'd like there to be, I'd prefer that we have as many options around that as possible.
And yeah, certainly we can opt to not make a requirement for it to be in person for everyone who are not in BOP custody, but I just want to also highlight the digital divide. I know everybody's great and very excited about everything being virtual, but not everyone has the capacity to have high-speed internet at home to accommodate WebEx or Zoom, or I think those considerations, the board should also consider that. So to allow for flexibility to do more in-person hearings.
Right.
I know I've, oh, sorry, go ahead.
I was just going to say, I think really what we're after here is, in whatever way works, that the presiding officer has the flexibility to allow digital divide issues to say, okay, we're absolutely going to be in person, fine, but I want that determination to be made, given the circumstances of that situation, and as many options available to the board as possible.
And one, I think I've highlighted this before, but if it is in person, just thinking through security, and just, I don't know whether people in the Wilson building would, be available in the event that there is a security concern to any person. But I think that that's something that should be thought through as well.
Yeah.
Okay. I think we could probably add a line within these procedures that state where locations the board will do all it can to make the location of a hearing accommodating to the applicant and witnesses to assure their attendance or something along those lines. Probably maybe something around here. Or assure the location
This is a separate question. I don't mean to interrupt you, but are these hearings being recorded? And if so, who will have access to that recording? And that kind of ties into the question of, I know that it mentioned that people will be sworn in. What, I know that can help kind of encourage truth telling, but kind of what is the, implications of somebody being sworn in?
So to address the first question about whether these board hearings should be recorded, I recommend we do minutes of some sort to conduct the hearing. If we do recordings, we have to think about how does the board have capacity to record a hearing? We'd have to get that technology to make sure there's a place where these hearings can be recorded. And I know there was discussion of maybe doing the location of hearings being within the courthouse or some conference room that does accommodate for these types of hearings. So it's certainly within the board's discretion, but I recommend conducting some sort of minutes. With respect to the sworn statements, is your question, Ilana, with respect to enforcement of those sworn
I'm just
statements?
trying to kind of ascertain like what the purpose of the sworn statements is. In court, it's because, if you don't tell the truth, you can be subject to perjury. I'm not saying that we should be, prosecuting people for perjury here, but that's, like that's usually the purpose, is because it encourages you telling the truth with a potential, enforcement mechanism of perjury if you don't, and if it's not recorded. I'm just trying to kind of, I don't have a clear answer. I'm just kind of thinking through implications of all of the options.
Certainly something I can take some time to look into. I didn't know if other board members had suggestions.
Yeah, I'm not sure I understand all the ramifications of recording or not recording. It seems cumbersome to me. And particularly if there's a summary being prepared, I would assume the staff director would help with that, and that the presiding officer would ultimately be the one who authors it. But I just don't know enough about the requirements of all that.
I think the recording and the sworn in are kind of two separate, possibly parallel questions. I don't really have clear answers to any of them. I've just had some questions. And sorry, also in terms of the recording, I know that it would be confidential. There could be some value in some cases in providing the recording to the pardon attorney for their consideration as well, if it's a particularly compelling statement that they make orally. There's a lot of emotion that can be captured in a recorded statement that can't necessarily be captured in a summary or in minutes. But I also recognize kind of wanting to have some confidentiality. So I kind of defer to others on that. I was just putting out some thoughts.
Thank you, Ilana. Any other board members?
This is Felisa. Yeah. Logistically, like if we recorded it, who's going to be responsible for keeping the recording and maintaining the recording and for how long? And in one instance, we're saying, well, we're not triers of fact, but then like we're trying, like what we're discussing now seems like we're almost kind of recreating a court setting, which I don't know if necessarily we want to do that. Things we're bringing up right now with recordings and swearing in things like that, it can cut both ways. I see benefits and negative issues that can come up both ways. Yeah. This is this is when we're getting in the weeds. It can seems like we're stopping progress. But anyway, Yeah, I don't know how I feel about the and yeah, I see benefits to recording, but then I can see where it can kind of shoot us in the foot too. Um, Depending on how victims feel about it, depending on how uh applicants feel about it. Um, uh, yeah, I'm kind of torn on this issue right now. So that's all I have to say about that.
Okay, Alana, I'm sorry, Christina, I want to do a time check. It's 11:28. I know that people had blocked. I think usually we block about an hour and a half. I'm just wondering how much longer you think.
So we blocked it off to a hard stop for noon.
Oh, for noon. Okay.
For noon. Mhm.
And I'm just checking to make sure that board
Still
members
have
are
quorum.
able to stay on until noon. If there's anybody who cannot, can you speak up? Okay, hearing none, we'll continue. Thank you.
Okay, thank you. Well, thank you for those comments. We can certainly, since these, the operating procedures are going to go back to the board for a second layer of review, we can certainly figure out all those details of the hearing procedure. But I didn't know if the board has no concerns about this one liner I just added, I can move forward, and didn't know if you had concerns about other procedure matters that were outlined here that you'd like to discuss.
If I could just ask one question, um, is this appropriate time for me to just ask a question?
Sure. That's one.
I'm sure. I'm sorry. I'm not a board member, and I'm just trying to figure out when I can speak and when I can't. One of the things that I suggested when regarding the hearing procedure is that the information that the board relies on to make a decision, that information be identified during the hearing so that the applicant knows what the board is looking at. I'm not sure if I saw that in here.
Right. So Professor Moy, that would make the hearing to be a deciding hearing, and that's not what it is. It would be a fact gathering hearing, because at that point, the board will not be making a decision. It would be gathering more information on the application. So I think it would be a very hard place for the board to release that at a point when it hasn't made a decision.
But will the applicant during the hearing be apprised as to what the board has in terms of gathering information? What information the board has in front of them at the time?
The applicant will know what information the board will be gathering. So everything on the ROI is enumerated, what documents will be pulled. So if it's the applicant's background, records and backgrounds, health records, all of that is enumerated in the ROI process, and it lists which specific documents the board will have. So yes, the applicant will know what background information we would be pulling.
Okay. I just think that that's important so that the individual is not then blindsided later um, by information that they didn't know the board was considering and told that, like this is the basis for why we're denying or whatever, and it be based on information that the individual didn't even know that the board was looking at.
You were correct, Mr. Moyd. We don't even get any background information without the express consent of the applicant to receive those documents. Any questions or concerns from board members about the hearing procedures?
I'm just grateful that we'll do a rotating basis of the presiding officer. I think that's really important for the efficiency of this. I worry about when we have volume coming through that be able to manage it that way. So appreciate that. Thank you.
Okay. If no concerns, certainly the board will have an opportunity to review this one more time, or two more times, or three more times, depending on how much will be needed. So confidentiality issues here. So Katya asked this question about whether closed meetings will be recorded, and I think this goes back to the question that Ilana brought up. I think the board should make a determination of what would be beneficial based on the concerns that other board members have just expressed. My recommendation was to employ minutes, partly because of the sensitivity of being recorded and not allowing free discussion and openness between, you know, applicants and the victims and witnesses. Some people may feel uncomfortable being recorded, but that's entirely the board's decision. My recommendation has been noted, but I didn't know if Katya, if you had a position on this, since she also brought it up.
Yeah, I'm not sure. Are the members who are not present going to vote?
So I think they should be able to make a voting, because they'll be able to review the application and the background information. We strongly encourage that everyone attend the hearing. So it's, you know, you need a quorum anyways to effectuate a board decision. So the voting can also be determined based on the quorum.
I'm sorry, did that answer your question though, Katya?
That answers my question. I don't want us to get into a position where we can't vote because we don't have a quorum, but at the same time, if people are voting to deny based on evidence that they didn't hear, that's also problematic. And I don't know how much minutes will bridge that gap.
Yeah,
Maybe it's the individuals who are present who should be able to vote on that particular applicant.
As long as there's a quorum.
what do you mean a quorum though? A quorum of the individuals who were present for the hearing?
A quorum of the board.
Of the,
So you need a quorum of the board to even hold a hearing.
right.
So I think Katya is highlighting that specific quorum that was in attendance for the hearing be also the individuals that vote on the application, and that board members that were not in attendance cannot vote.
So practically, you could have like 5 people there who are the quorum, and you would need a majority, so you would have 3 people who vote to approve it.
Unless every board member commits to be in attendance of every hearing.
So is the board comfortable with that? So
This is Felicia. I thought it was, like, at least my understanding, I could be wrong, that, yeah, you had to be present to vote on someone's application. You have to be present to vote at a meeting. So, yeah, at a hearing, I know, I think I haven't looked at the bylaws in a while. I know there may be, I don't know if there's a difference between the hearings and the meetings, but yeah, it was my understanding you had to be present at a hearing to vote. I guess I have to go back to the bylaws. But, and to me, it seems only right that to vote on an applicant, you should have been at the hearing.
Mm-hmm. We could certainly add that if that's what the board decides.
is there any other discussion about that? Okay, so yeah, I think we should go ahead and do it that way.
Okay. Then I will add it to the hearing procedures above. Following hearing.
I'll just note, I know that practically there are concerns because people have schedules. But I do feel like 3 people basically voting in favor kind of has less, persuasion than more than 3. If kind of 3 is essentially the minimum that would be required to move someone forward.
I think a quorum would be, well, in any ways, a quorum for us would be 5 at this point, right? So what you're saying is it would be 3 of 2 is what you're saying, Ilana.
It would
for
have to be a
approval.
majority of the quorum present, right? Which means that it could be as low as 3.
Mhm.
Correct.
I kind of defer to others on this. I was just noting that it feels less persuasive to have 3 people supporting that person than more.
Well, is the vote necessarily something that is publicly recorded? I guess it happens at the public meeting, right?
Considerations of applications are not publicly recorded.
So the vote is not recorded.
I mean, another option is to require that if a hearing is held, that all board members attend. Might create some logistical issues.
No, administratively, that would be impossible.
I will just add this in here.
Because when we get to the hearing aspect of I guess within the meeting, that's when the meeting would be closed because it would be confidential what we're discussing. So with a vote, I think a vote would qualify as something confidential on which because we're like giving people's names, discussing issues like, as we're voting, I would think that would be part of a closed procession of of a meeting or hearing because of the confidentiality issues.
Okay, so can I just run through this? Hearing is held, it requires a quorum. Quorum is 5. So we have a hearing. You see witnesses, you take testimony. The hearing is ended. Then there's a staff report created that summarizes the hearing that is then brought to the full board at a board meeting. That can be discussed in closed session in the board meeting, and then a vote only of the people who participated in the original hearing is taken. And that's considered deliberative, and so is not part of the public record.
Correct. Only the board rec decision is public. That's a final determination. So if the board decided to issue a letter of recommendation or not, that's the only thing that's public.
Okay.
Another option is to require a quorum plus, so a larger quorum of attendance for a hearing, but certainly something I will add a comment here that this be sent back for further consideration for the board.
Thank you.
Okay. Going back, I believe we were here. Katya, I think you said this conflicts with the confidentiality question here, disclosing information from a closed meeting to other board members who were not in attendance is permissible, that a member of the board who discloses information shall take reasonable steps to ensure that the information disclosed and the persons whom the information is disclosed are limited as possible. I think that goes for outside the board. If an unwanted disclosure happens, people make mistakes, and that the board will do everything to mitigate that disclosure. Does that answer your question, Katya? So, I'm wondering if more language can be added there to make it clearer. Okay.
Yeah, something like a member of the board who discloses information to non-board members, right?
Yeah, I think that would work. Okay. Does that suffice? Okay. Here was just that we still require members who participate in the evaluation of the application to sign an NDA. The reason why I think we added that requirement is I think the board was considering maybe getting, if we were to recruit, like, let's say, a clinic to help an applicant with the application procedures and they wanted information from the board, that we would just ask them to sign an NDA for confidentiality reasons or so forth.
Okay, person who participates in the evaluation of an application, the clinic would be somebody that the applicant themselves would be supported by?
Right, right. Or do we want to, another option is also, do we want to partner with a clinic that can help the board in the collection of those documents, those background documents? So to work with the staff director to possibly reach out to various sources, so they would sign an NDA agreement to work with us. That's, we could also remove that and just require it of the board members. Just allowing some flexibility here for what the board could be in the future.
Yeah, I guess the participate in the evaluation of applications is what was unclear to me. If it's supporting the creation of a viable record, you know.
Can we just clarify? So what exactly would this apply to? Are we talking about like the documents collected by the board? Are we talking about, information learned during the hearings? I think some of this is kind of similar to what I raised before, and I think that there's some valid reasons to constrain board members from, over disclosure. But I think other people might and perhaps should have less constraints. Lawyers are bound by ethical obligations, but yeah, I think that there is some interest in some confidentiality, but I also think that there are some things that should not be deemed overly confidential, and it's a balance to find.
So with respect to the board members, obviously that's just considered confidential. This would apply to confidentiality for everything, right? And maybe we do need to separate these out. With respect to other persons, I was just trying to create more flexibility for the board to see how we could essentially have other individuals help with the collection of those documents. So the NDA would apply to the collection of those documents, not not to the evaluation of application. So I certainly agree with maybe modifying that language. Did I answer your question, Ilana?
Yeah, and I mean, a lot of the documents that we're talking about, I think, are public documents that, any member of the public, I recognize that it's sometimes practically hard to get them, but once somebody has them, I think it would be appropriate for them to share something that is in the public record, a document from Superior Court. I recognize some things might have more privacy protections and kind of, I don't know. I was just trying to think of kind of specific things and addressing each one appropriately.
Now, certainly agree, like some of these documents are publicly available, but the way we get them is through an ROI process. We get the consent from an applicant, and while not all of these documents are readily available online, they have to be they have to be retrieved from an organization or an agency or through a microfiche process, depending on the age of them. So because it is, because of the nature of the board, the reason why those documents are even accessible is because the board has put in procedures to receive them. So even though an applicant can go and get them themselves, they wouldn't be able to get them as quickly because those procedures are in place. So we'd want to be able to protect those documents as much as possible. Okay. With that, I guess my recommendation would be all board members who participate in Clemency board business are required to sign a non-disclosure agreement. Just keep it very general.
Okay. Is an NDA really, it's already stated in our, in this process that it's confidential. The NDA, is that I sort of don't want to overkill. I do want to protect confidentiality, but I don't want to overkill that.
Yeah, I don't like the NDA language because certainly we'll keep confidential information confidential. But an NDA, just particularly when you're a government agency, makes it feel like we are protecting information from public disclosure that the public might have a right to. And I know that's not what we're doing and what we would do, but I don't like to use that terminology in this context. And so I do wonder if we should just put general language about something like that the board will maintain information obtained through, because I take your point, Christina, that information that we receive through this process, we have sort of an agreement that we're going to keep it confidential. And so I just wonder if we put in some language about information obtained through whatever the terminology used will be maintained in a confidential manner by the board or something like that.
I agree with that too. I think there will be more reluctance to serve if there's a separate NDA that people have to execute in order to join the board.
Mhm. I was going to say ROI process, but then when you spell it out, it's request for information retrieval process, but I guess the background retrieval process. Uh, do we want to, will be treated with, Emily, I missed the last part where you stated with utmost confidentiality or with.
Yeah, what I said doesn't work. Actually, I said will be maintained in a confidential manner, but I don't think that's quite what we mean.
I guess you could say the board, information that the board obtains. Because partly each organization has different confidentiality handling instructions for various documents. So one document will be treated differently than the other document. And so ultimately, there's not a one rule fits all documents type of. I think the idea is to make sure that information is protected according to the instructions of the releasing agency. Does that suffice?
I think it's good.
All right, 5 minutes to go. I think we don't have much, but, okay, so here Sonia's comment, Sonia's not here today, but her comment was, isn't the first question that we need to ask whether or not the applicant has filed a DOJ application, otherwise they're not eligible for a recommendation from us. I'm sure we all remember that that was the major change that we had conducted after receiving public comments, that we no longer require that an applicant have a DOJ application pending with DOJ pardon before they can come to us for a letter of recommendation. But again, we'll submit Appendix A and B for the board's review. Ilana, I didn't know if you wanted to express concerns about the pre-sentence report. I know you wanted to do that at the meeting.
Sure. I also see a chat.
I think it's Matt Ornstein.
Hi. Hi, can you see me? There we go. Sorry, just with the time running out, I just wanted to make a very quick comment. My name is Matt Ornstein. I'm the Strategic Litigation Director over at Network Victim Recovery of DC. I just wanted to make a quick comment about when we were talking earlier about the amount of time sort of allotted for each witnesses to talk. And I think what I would urge the board to do is whatever amount of time, whether it's 5 or 10 minutes, I think you should make sure that there's parity between the amount of time that victims have to speak and any of the other witnesses. I think probably most of the time victim impact statements won't go the full 10 minutes, but I think it's important that, if they do, they have the sort of same opportunity as everybody else does. But even more so than that, I think the messaging that, victims aren't a lesser witness than anybody else in the proceeding is pretty important, just from a, the way things look perspective, and sort of setting the right tone going into these hearings. Thank you.
Thank you for that comment.
Thank you, Matt. Okay. We'll certainly add that in. I'll make sure to add a comment in there for the board to consider, Matt's comment. So Ilana, just want to turn it over to you to know if you wanted to express your concerns about the pre-sentence report.
Sure, thanks. And I agree with Matt, and I think those are good points that he made. In terms of the pre-sentence report, so this is something that we have started talking about. The pre-sentence report, as people probably know, has a lot of valuable information. It is also fairly well protected within the criminal justice system, and it's not widely disseminated. It's not available on the public docket, and it's a wealth of information, but also there are some privacy concerns with overly disseminating it. I think my understanding is that people in BOP custody are not allowed to possess their own pre-sentence report. So I think that we just, need to have a good conversation about if the Clemency Board should be accessing this, and if so, kind of how that will work.
So we had a conversation with DOJ Pardon, and they, this is part of their consideration when making clemency determinations. So ultimately, I think that's something that the board should also have. But we received the pre-sentence report through an ROI process, so we're getting express consent from an applicant to receive it, and also express consent from an applicant to send that information to the President of the United States. So the pre-sentencing report is not going to be disseminated widely to other folks other than the DOJ pardon, the president, and of course the board and staff director. The concern is I did not know that. I thought an applicant, anyone can receive access to their pre-sentence report if they requested it. Is that not correct? Because I believe people in BOP custody, the pre-sentence report also contains progress reviews. So if an applicant or anyone, a member of the public wanted it, they could receive it. So is our concern sharing that information with someone who's in BOP custody?
Katya, you might be able to better speak to that if you are able.
The public can't get the pre-sentence report. And the pre-sentence report does not have any progress reports. I mean, it might have progress reports from prior incarceration, but it's not a continuing document that is updated after the sentencing. It is done for sentencing in Superior Court. I think it's done federally too. And then it is given to the parties. It's my understanding that clients can't have it in the BOP, even though it exists and their lawyers have it, they're not allowed to possess it in the BOP because of the private information I guess it contains. I'm not sure exactly the reasoning, but that's my understanding, is that they're not allowed to have it within their own paperwork.
So that would be one of the documents we could not give to the applicant as a supporting document when we, let's say if we decided to issue a letter of recommendation, we would withhold the pre-sentence report.
Yes, I mean, I think we should confirm with BOP their current policy on it and if it can be sent back, but that's been my understanding of the past.
So it's,
And then-
that's who we would get that document from. We wouldn't get it from BOP.
CSOSA creates it. BOP and DOJ have copies of it because they use it also in, I think, in the designation process. Ilana, do you know that part? I think that's true.
I'm sorry, can you repeat that last?
That they DOJ and BOP both have the pre-sentence report, but I think we would get it from CSOSA.
That sounds right, but I can't confirm, but that sounds right.
Hi, this is Professor Moy. It is the current policy that individuals in BOP cannot have a copy of their PSI report. That is still the case.
Okay. Well, thank you for that. I will confirm with BOP, but I think the language that we put in that, documents will be handled according to that agency's restrictions is in alignment with this, but I think we certainly should still have access to it for review. Just ultimately, it may be a document that would not be provided to the applicant.
Okay, thank you for that. So it's 12:02. I've already asked people if they could stay till 12. I apologize for going over. We're going to need to have another meeting on this. I'd propose Friday, July 16th at 10 a.m. for our next meeting. And again, we're at this funny quorum kind of place right now, so I would really just love to hear from members that you're able to participate that day. It's Friday, July 16th.
This is Felisa. I can participate.
Thank you.
July 15th at 10?
It's Friday. I believe it's, isn't that the 16th or is
I
it?
think it's the 15th.
I apologize. So Friday, July 15th at 10 a.m.
I think I can.
Okay.
I
This is
can.
Emily. I'm sorry. I'm available as well.
Katya? Katya, you said yes?
Sorry, I was marking it on my calendar. I said yes.
Awesome. So we have 5. So Friday, July 15th, 10 a.m. We'll meet again. Thank you all for your participation today. It's been a very robust conversation. And thank you to the public participants as well. We didn't have a formal public comment, but I was pretty liberal letting you speak when it was pertinent during the process. So I hope that suffices for this time. Thank you, everybody.
Thank you.
Thank you.
Bye
I
now.
didn't know if you were going to motion, Patrick.
Oh, of course I am. Is there a motion? Make a motion to adjourn. Who seconds it?
I do. Elisa.
Fantastic. All those in favor? Aye, everyone's okay. We're adjourned.
Bye.
Thank you,
Thank you.
Christina.
Thank you,
you.
Christine. Appreciate
Bye,
it.
everyone.
Bye now.